In the previous video, we have learned section 13, which deals with transfer to unborn person. If you haven't watched the previous video, I have given the link in the description box, which you can check it out. In this video, we are going to learn section 14, which deals with rules against perpetuity. The dictionary meaning of the word perpetuity means security or interest with no fixed maturity date. According to Black's Law Dictionary, perpetuity means a thing which is forever or for all times. Thus, a perpetuity is a type of annuity that lasts forever. The policy of law has been to prevent property from being tied up forever. There are basically two ways in which property may be tied up or rendered inalienable. Firstly, by imposing a condition absolutely restraining the transferee from parting with it or disposing of his interest in the property. And secondly, by creating a succession of future interest in favor of an unborn person by postponing to a remote period. Section 10 of the Act strikes the first method by invalidating the condition against alienation, and Section 14 restrains the power by creating future interest by providing the rules against perpetuity, that such interest must arise within certain limits. Perpetuity is an interest which will not vest till a remote period. One cannot postpone the vesting of property in a transferee beyond a certain limit. The period for which vesting may lawfully be postponed is called the perpetuity period. The rules against perpetuity is contained in Section 14 of the Transfer of Prperty Act. Section 14 provides that no transfer of property can operate to create an interest which is to take effect after the lifetime of one or more person living at the date of such transfer, and the minority of the same person who shall be in existence at the date of expiration of that period, to whom, if he attains full age, the interest created is to belong. Thus, this section says that no transfer of property may serve to create an interest which is to take effect after the lifetime of one or more person living at the date of such transfer, and the minority of the same person who will exist at the end of that period, to whom, when he reach full age, the interest made on the property is to belong. Thus, in simple language, a transfer of property cannot create an interest beyond the lifetime of one or more person living at the date of such transfer, and the minority of the same person who will exist during the expiration of that period, to whom, when he reaches full age, the interest created will belong. To take an example, A, B, C, and D are all living when a transfer was made by a man in favor of A for life, afterward in favor of B, C, and D successively for their lives. Here all the successive transfers are valid, as the person benefited are all in existence at the date of the transfer. But when a unborn persons are intended to be benefited, a threefold restriction is put on the power of the transferor. That is, the unborn person must be given all the remains after the determination of the intermediate interest. The interest must vest within the maximum period provided by the section, and the unborn person must come into existence on or before the expiration of the existing life or lives. It is permissible for a person to postpone the vesting of state to a number of living persons, but he cannot postpone in perpetuity, that is, beyond the lifetime of a person in existence on the testator's death, and the minority of some other person who is not in existence then, but born before the death of the last person to whom a life state is given, and to whom, if he attains full age, the thing bequeathed is to be belong. The rule against perpetuity is not concerned with contract as such. Number B. Contractual right and obligation as such. Thus, a contract to pay money to a person, his heirs, or legal representative upon a future contingency which may happen beyond the period would be perfectly valid. Walsh versus Secretary of State for India. It is therefore well established that the rule of perpetuity concerns right of property only, and does not affect the melting of contract which do not create the right of property. Now let us come to the exception of the rules against perpetuity. The following are the exceptions to the rules against perpetuity. Number 1. Where transfer is for benefit of public. According to Section 18 of the Transfer of Property Act, the restrictions in Section 14, 16 and 19 shall not apply in case of transfer of property for the benefit of the public in the advancement of religion, knowledge, commerce, health, safety or any other object beneficial to mankind. Number 2. Personal agreement. Personal agreement, that is to say agreement which do not create any interest in property, do not offend the rules against perpetuity. Number 3. Vested interest. Rules against perpetuity does not apply to vested interest. Hope you have understood the concept of rules against perpetuity as enunciated in Section 14 of the Transfer of Property Act 1882. In the next video, we will be dealing with another topic. So stay tuned. If you like this video, please subscribe to my channel, and if you have any doubt, you can comment me in the comment box. Thank you.